Welcome and thank you for joining part 3 of Seyfarth's 2024 Cal-Pecs webinar series on new developments in leaves and accommodations. All participants are in listen-only mode, but are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. The presenters will do their best to get to everyone's questions. For those interested in CLE credit, an attendance verification code will be read during the presentation. We've recently introduced a streamlined process for accessing and submitting CLE forms. Towards the end of the presentation, you will notice a QR code on the left of a slide and all the necessary information on the right-hand side. Simply scan the QR code with your smartphone and it will direct you to a digital attendance verification form. Once you've completed the form, you can submit it electronically. This saves time and ensures accurate processing of your CLE credits. Copies of the webinar recording and presentation materials, along with the CLE form, will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Anne-Marie to get us started.
Thank you very much, Brenda, and good morning, good afternoon, depending upon your time zone. I am Anne-Marie Zalatel, and I am a labor and employment partner based in Seyfarth, Century City, and New York offices. And I'm here with my colleague, Michelle Ducharme, who is an associate in our Sacramento office. And we're delighted to be with you here today to update you on some key 2024 and 2025 developments in the area of leaves and accommodation. So I realize we only have 30 minutes, so we have a jam-packed 30 minutes for you. So with that, we'll just turn to the next slide on which we've listed the topics that we are going to cover today. Going to take a look at some California paid family leave updates, as well as reproductive loss and statewide paid sick leave developments, and close out our session today with some updates to the jury, court, and victim time off and accommodation provisions that will be going into effect on January 1st of next year. Next slide, please. So first, California paid family leave, and I'm referring to the paid family leave wage replacement program. Sometimes, especially those of you who are based outside of California, believe that the California paid family leave program provides employees with time off from work. It is not. It is simply a wage replacement benefit. They have to be on an approved leave of absence under some other law, such as the Federal Family Medical Leave Act and or the California Family Rights Act. California's wage replacement program provides partial wage replacement benefits when employees are on approved leave of absence. And so some changes that took effect on January 1st of this year, the maximum weekly benefit remained at $1,620 per week. It is projected to remain the same for 2025, although that still could change. So definitely keep an eye out on that. The withholding for California SDI, which is the State Disability Insurance Program, and PFL, the withholding rate increased from 0.9% to 1.1%. And there was a significant development when it comes to wages that are subject to the PFL and SDI withholdings. Up until January 1st of 2024, there was a limit on the wages that were subject to withholdings, and it tracked the limit on wages subject to Social Security withholdings. So for 2023, that amount was $153,164, and any wages that an employee earned in excess of that amount were not subject to the withholdings. But as of January 1st of this year, all wages are subject to the SDI and PFL payroll tax and withholdings. Next slide. So at the end of September, Governor Newsom signed AB 2123, and among other things, this bill eliminates employers' ability to require employees to use up to 2 weeks of accrued unused vacation before they become eligible for PFL benefits. When the PFL wage replacement program was enacted, employers expressed concern that if employees were receiving the wage replacement benefits, they could return from leave and potentially have a lot of vacation still available, and then want to use vacation time sometimes when they've already been out on lengthy leaves. And so the legislature, sort of as a compromise, provided in the original statute that to address this concern, employers could, if they wish to do so, require employees to take up to 2 weeks of accrued unused vacation, and that way exhaust some of their vacation before they became eligible for PFL benefits. And unfortunately, that option is going away as of January 1st, 2025. And with that, I am going to turn it over to Michelle to talk about reproductive loss leave.
Thank you, Anne-Marie. The next update we want to share with you is with respect to California's reproductive loss leave. This went into effect in the beginning of the year and is a right under California's Fair Employment and Housing Act. So as you see on the slide here, all California employees who have worked for an employer for at least 30 days are now eligible for up to 5 days of leave after reproductive loss, which is a miscarriage, unsuccessful assisted reproduction, failed adoption or surrogacy, or stillbirth. Eligibility includes employees who work for public employers of any size or private employers with 5 or more employees. An employee can take leave following their reproductive loss event or that of another person, such as a spouse or partner, if the employee would have been the parent of the child born or adopted. Leave does not need to be taken all at once, but must be completed within 3 months of the triggering event. As you see on the slide here, if an employee experiences more than one reproductive loss event in a 12-month period, they're entitled to no more than 20 days leave in the 12-month period. Next slide, please. Thank you. So here you see that employees can receive paid leave under an employer's paid bereavement leave policy if the employer has one. Otherwise, the leave would be considered unpaid. Employees can also use available paid time off, such as sick time, vacation, or PTO, rather than taking the time off as unpaid. The law does not require an employee to submit documentation in connection with a reproductive-related loss leave. We do recommend not requiring documentation as the best practices approach. As a reminder, employers are generally required to keep confidential any information an employee provides when exercising the right to reproductive loss leave. And with respect to retaliation, this means an employer cannot fire, discipline, or otherwise discriminate against someone for requesting or taking reproductive loss leave. I'll hand it back to Anne-Marie for the next topic.
Thank you very much, Michelle. So there have been some pretty significant developments with regard to California, the statewide California paid sick leave law, otherwise known as the Healthy Workplaces, Healthy Families Act. And there first want to cover some 2024 developments. Hopefully you're all aware of these changes. So as of January 1st of this year, the annual use limit for statewide paid sick leave increased to 40 hours or 5 days, whichever is greater. And what this means is if an employee works, say, a 10-hour, they're regularly scheduled to work 10-hour days, they would be entitled to, it's 5 days, so 50 hours. So whereas an employee who works 8-hour days receives the 40 hours. If you have employees who work part-time, say 6 hours a day, they also would receive the 40 hours because it's 40 hours or 5 of their work days, whichever is greater. And before January 1st of this year, the annual use limit was 24 hours or 3 days, whichever is greater. And as of January 1st of this year, the maximum point in time accrual cap, for those of you who use the accrual method to provide sick leave, that increased to 80 hours or 10 days, whichever is greater. The cap previously had been 48 hours or 6 days, whichever is greater. Also, as of January 1st of this year, employees may take sick leave for a designated person. And for purposes of the statewide sick leave law, a designated person is a person identified by the employee at the time he or she requests paid sick leave. So that person does not have to be a family member, really can be any person. The legislature has provided that an employer may limit an employee to one designated person per 12-month period for the purposes of paid sick leave use. So it's not as if you have an employee who can say, well, I want to take paid sick leave to care for this friend today, and 2 days later, oh, I've got another friend who's sick and I need to take care of him. So if you are going to rely on this provision, though, it's critical that you have it. You need to have it in your written policy that an employee may designate only one person per 12-month period. Next slide, please. So coming January 1st of 2025, there are some pretty significant changes to the statewide paid sick leave law. So the law currently provides that employees may take paid sick leave for, among other reasons, if they themselves are a victim of domestic violence, sexual assault, or stalking, as those terms are defined in sections 230C and 231.A of the California Labor Code. As of January 1st, paid sick leave will also be available when the employee's covered family member is a victim. And on this slide here, we've included for you all of those individuals who are considered cover family members under the statewide paid sick leave law. Additionally, there's an extension of victim status to additional crimes. So right now it's domestic violence, sexual assault, or stalking. Those, of course, still remain in place. And if we go to the next slide, we can take a look at the additional victim status. So it's an act or conduct or pattern of conduct that includes any of the following, in which a third party causes bodily injury or death to another individual, exhibits, draws, or brandishes or uses a firearm or other dangerous weapon, and finally uses or threatens to use force against another individual to cause physical injury or death. And then additionally, the reasons for use of safe time have been expanded. And the first two reasons are on this slide, and you'll be receiving these slides. We don't have time today to read through all of the reasons, but you will receive copies of these slides so you can have the reasons handy. And on slide 15, we've included additional reasons. If we can move to slide 15, and you'll see these reasons include safety planning, to obtain services from a victim's organization, to obtain counseling or mental health services, to participate in safety planning. And if we go to the next slide, slide 16, there's still an additional 4 reasons for which employees may take the safe time leave. And again, this applies if either themselves or their covered family member are a victim of, one of the 4 types of qualifying violence that we discussed on the prior slide. So again, just a lot more reasons employees can use the paid safe time component of the Healthy Workplaces, Healthy Families Act. And with that, I am going to turn it back over to Michelle to cover our last, actually, sorry, I forgot to cover one additional development here. I don't know if any of you have agricultural employees, but as of January 1st, agricultural employees, and that term is defined in the labor code. We've had the section up there for you in case there's any doubt whether you employ agricultural employees, but they can take paid sick leave to avoid smoke, heat, or flooding conditions created by a state or local emergency, including, but not limited to, when the work site is closed due to smoke, heat, or flooding. This expansion, I think, is due in part just to the unfortunate increase in wildfires and flooding events the past few years in California. And, with employees either not able to get to work or with the work site closed, the legislature wanted to address, those employees who are outside and therefore not able to work by, allowing them to use any of their accrued and available paid sick leave. And with that, I will turn it over to Michelle to cover our next development.
Thank you, Anne Marie. Yes, finally, we do have some important updates to California employees' rights to jury leave and victim time off and accommodations. So as Anne Marie touched on earlier, there is unpaid leave and accommodation provisions in the California Labor Code sections 230 and 230.1. And this provides for leave and accommodations for victims of domestic violence, sexual assault, stalking, or crimes, those serving on a jury, and those complying with a subpoena or court order to be witnesses in court. So as of January 1st, 2025, these provisions are going to be recast as grounds for unlawful practices under California's Fair Employment and Housing Act, which is FEHA, placing them under the California Civil Rights Department's, or CRD's, enforcement authority. So it's possible you can see an uptick in litigation involving these leave provisions because they are now going to be available as a claim, first as a claim with the CRD, second as a potential claim in California courts, which carries with it the right to attorney's fees for an employee/plaintiff who might pursue such a claim. So it's essentially going to make unlawful employment practices under FEHA to discriminate or retaliate against an employee who is taking time off to serve on a jury, an employee, including an employee who is a victim, for taking time off to appear in court to comply with a subpoena or court order as a witness in any judicial proceedings, as well as an employee who is a victim or who has a family member who is a victim for taking time off from work to obtain any relief. And that relief is exhaustively defined, and it can include a TRO or ensuring the health and safety of the victim. Regarding the latter, as a condition of taking time off, an employee should give the employer reasonable notice, but only when feasible. In some of these circumstances, it is not, but you can request that the employee provide reasonable notice when feasible. Next slide, please. So as of January 1st, 2025, these provisions are also expanded. So the law prohibits discriminating or retaliating against or terminating an employee now for taking time off for jury service with reasonable notice, taking time off to appear in court as a witness or under court order. Now, if the employee is a victim, for taking time off to obtain relief for the employees and or the employee's child's health, safety, or welfare. You see here we've got bold down at the bottom, we have for employers with 25 or more employees where the employee or the employee's family member is the victim. you're prohibited from discriminating, retaliating against, or terminating an employee for taking time off for various reasons related to a qualifying act of violence. That's also defined to include, and Anne-Marie touched on this a little bit earlier, but that's going to include any of the following. So domestic violence, sexual assault, stalking, or an act, conduct, or pattern of conduct that includes bodily injury or death, in which an individual draws, brandishes, or uses a firearm, and which an individual uses or makes, reasonably perceived or actual threat to use force against another individual to cause physical injury or death. So there's a lot here that is covered, and it's going to be even more important, as it already was, to ensure that your employees are aware of their rights under this law, as you'll see on the next slide if you can. So first, with respect to employees' use of time here, they can use vacation, personal days, and paid sick leave for what would otherwise be unpaid leave under these provisions. The leave would also run concurrently if it qualifies for leave under FMLA or CFRA. The law also extends eligibility for reasonable accommodations to include not only employees who are victims, but also employees who have family members who are victims of a qualifying act of violence, which we talked about earlier. With respect to reasonable accommodations, this can include a number of different options here. It can include the implementation of safety measures. It can include a transfer, reassignment, a modified schedule, changed work telephone or permission to carry a telephone at work, changed workstation, installed locks. There are a lot of different options that are defined here for reasonable accommodations. Another important reminder is that an employer should always engage in a timely, good faith, and interactive process with the employee to determine effective, reasonable accommodations. We always recommend that you're documenting each step of the reasonable accommodation process. That was important before, and it's, of course, even more important now as this is going to fall under FEHA. And again, you could see an uptick in litigation involving these claims. So you want to make sure that you're following, complying with the law, but also documenting every step of the way and having your employee acknowledge what you're doing to help in terms of reasonable accommodations. Now, in determining whether the accommodation is reasonable, the employer should consider an exigent circumstance or danger facing the employee or the family member, so you always want to take that into consideration. Now, one of the other very important updates with respect to this change in the law is that there is a new notice requirement. So after the Civil Rights Department issues a model form online, which is expected to occur on or before July 1st of next year, you have to inform your employees of their rights under the law at the time of hire, annually, upon an employee's request for leave under these laws, and anytime the employee informs the employer that they or their family member is a victim. Those are very important notice requirements, and something that you need to definitely counsel your representatives who are working directly with your employees on remembering this, because it is, again, it's falling under FEHA. It's going to be something that they could pursue a claim with, and best practices to make sure that your employees are protected and informed of their rights under these laws at all times. And this is a great time to look at whether your policies are up to date or need to be updated in your handbooks or however else you communicate your policies to your employees. This is a great season to do that. So we're happy to help with any questions you might have with respect to any of the policies or changes in laws that we've talked about today. So with that, we can go to the next slide. So this is our new CLE code. So you're going to scan this code that's on your screen right here, and it's going to take you to a website. You also have here the attendance verification code. I'll read it out for everybody as well. It's SS, as in Seyfarth Shaw, 4215. So we'll keep that up on the screen there for you to scan. We really hope that you enjoyed our presentation. We are happy to answer any questions or speak with any of you individually about these updates or updating your handbooks or any policies that you might have questions with. Thank you very much for your time and attending.
Yes, thank you very much, and have a great rest of your day.